hearing those submissions.
Honourable John Banks.
Mr. Speaker, I must say I've enjoyed working on the Parliamentary Privileges Committee with this previous Speaker and others. The bill is to be read alongside Article 9 of the Bill of Rights 1688, or in the new calendar 1689, and common law privilege. It affirms aspects of the law and conventions regarding parliamentary privilege, including those in standing orders of the House and from various legal conventions and precedents. And this country is well behind other Commonwealth countries in getting these matters up to scratch and contemporary. But it does not codify or replace them, that is, the various legal conventions and precedents. The Parliamentary Privileges Bill, so that people listening this afternoon understand that it defines proceedings in Parliament to include, amongst other matters, where the officials provide material for ministers to respond to and oral answer questions, which is the reason why this matter is being addressed at this time. It's actually been a Trojan horse for just that. It provides statutory guidance on how to interpret impeached or questioned, clarifies the protections afforded to certain broadcasts and reports on proceedings in Parliament, makes explicit that a statement made during parliamentary proceedings may not be used to determine criminal or civil liability in respect of a statement made outside of Parliament. And it affirms and modernises existing laws, including affirming the House's power to fine for contempt and resolving a number of minor technical issues. The bill, Mr Deputy Speaker, repeals the Legislature Act 1908 and the Legislature Amendment Act 1992 and amends the Defamation Act of 1992. It is work that is well overdue for this Parliament in terms of other parliaments around the Commonwealth in particular. And as the previous Speaker said, in 1688 or 1689 new calendar, the House of Commons passed the Bill of Rights Act. The Bill of Rights Act was a statutory reinstatement of some of the most important basic rights and liberties of English citizens, and it forms part of our laws. Most would recognise these fundamental civil and political rights. For example, taxes can only be raised by Parliament and not by royal prerogative. The right of bail and to be free from cruel and unusual punishment, that justice is done by impartial judges and courts, it's not a personal matter for the Crown, and that the Act touched on succession laws for the monarchy. Many of the rights enshrined in the Bill of Rights Act 1689 are reproduced and fleshed out in our laws right across all the statutes and the laws of other common law nations that we refer to. The Bill of Rights Act speaks to us from the past, and it's critical to our future and to the role of this Parliament and to the rights of every single member of this Parliament, because, as I've said before, every single member of this Parliament is an equal. No one is more important or has more rights than anyone else from every single corner of this House. Some of the provisions concerned Parliament and its privileges. The general law around the rights of this House is known as the law of privilege. It is part of a rich inheritance of the common law that is every New Zealander's birthright. The 1689 Bill of Rights Act is the font of the law of privilege. It is the font of the law of privilege. It's what we stand for and what we stand against in this House when doing the business of a democratically elected society and of individually elected members of Parliament, equal under the law and in this House for our actions in this House and the laws that are passed by majority in this Parliament. It is said that the election of members of Parliament is to be free from interference from the Crown, and it's often not well understood that there is a difference between members of Parliament and ministers of Crown, members of Parliament and ministers of a government, and members of Parliament and members of Parliament as part of a government. The 1689 Bill of Rights, as I said, is the font of the law of privilege. More importantly, for today's purpose, it is said that the freedom of speech and debates or proceedings in this Parliament ought not be impeached or questioned by any court or place out of this Parliament. And that is why we're having this discussion this afternoon. That is why we have this bill. That is why we've got this legislation going through the Select Committee process around these corridors. This Parliamentary Privilege Bill deals mainly with freedom of speech and debate in Parliament and its impeachment elsewhere. The Privileges Committee must consider whether the law of privilege is clarified to extend to cover an official's advice to the Minister for the purposes of answering oral questions in this House. While MPs often complain about the quality of ministers' answers in this House, it is an important part of holding the executive branch of government to account. These issues arose in a case where the comments of an official to a minister in the context of preparing the minister's answer to a question, a parliamentary question, was held to be defamatory by the courts in Gale v Lee. It is Parliament's view that this is a process of Parliament and therefore covered by privilege. It is the view of the courts that it is not. That is why we have this discussion today. That is why we have this bill, this first reading, and that is the matter that's going to be addressed at Select Committee over the next few months. Ultimately, the scope of law of privilege, save any statute, is a matter for the courts to determine. So as the law of privilege stands currently today, Mr Deputy Speaker, official advice to ministers in the context of preparing for parliamentary oral questions is not covered. It is in most other Commonwealth jurisdictions, and it should be in this House. The House must wrestle with two competing interests. First, is such an extension or clarification necessary for the proper functioning of this Parliament? My view on that is yes. Here we must focus on the effect of free and frank advice to ministers operating as members of Parliament in this House and their responsibility for their words and for their actions in this Parliament. Second, it is also necessary that citizens will be denied a remedy. It is so necessary that citizens be denied a remedy for potentially defamatory statements made by officials in context advising ministers for answers to parliamentary questions. The bill also deals with the rules around restatement and adoption of statements in the law. Classically, a member of Parliament cannot themselves repeat a potentially defamatory statement made inside the House, but others can do so in good faith. This strikes me as somewhat artificial and unduly complex, and in most jurisdictions in the Commonwealth, Mr Speaker, this has been dealt with. The bill also includes a number of other technical fixes around contempt and the power to fine. I await with interest the submissions of these issues that will be considered carefully by the Privileges Committee. It is probably timely to shift more of the law of privilege into a statutory restatement. Now, Mr Speaker, these are matters, lofty matters, but important to the functioning of a parliamentary democracy and to the functioning and rights and responsibilities of every single member of Parliament to work in this House in the best interests of every single other New Zealander outside this Parliament, in the best interests of a truly functioning parliamentary democracy. So I hope that this will, with those who come into contact with the law of privilege, to be better locate in relative law and understand it. In other words, it's our responsibilities as part of this reform to reach out to the public, to those that we serve, so that they clearly understand our responsibilities to them, working for them on their behalf in this parliamentary democracy, this debating chamber, this font of all legislative change, and hopefully change for good.
Honourable Trevor Mallard.
Mr Speaker, it's pretty rare that I get